Welcome, everyone. My name is Susan Reed, and I am a managing attorney here at the Michigan Immigrant Rights Center. We are so glad you are here. If you are an American immigration lawyer, especially one specializing in humanitarian immigration, Canada is on your mind a lot and more lately. And so we were so glad when we were chatting with our good friend and colleague, Alex Vernon, at the University of Detroit Mercy Law School, who is our Canadian commuter back and forth from Windsor to Detroit to teach there at Detroit Mercy. We were so glad to connect with him and some of our Canadian friends and his Canadian friends and bring these wonderful panelists together. So our webinar today will consist of 4 sections, each presented by a panelist. And we will, after each panelist presents, we will open the floor to questions for the panelists. Please do either save your questions until the end or enter them into the chat for a moderator to read out during the question and answer section. So you can again raise your hand at the end or enter those questions into the chat. Thanks to Hannah Laker from Merck, who is our moderator today. We have a few little Zoom logistics. Please stay on mute when you're not speaking. During a meeting, you can click on the icon labeled participants at the bottom center of your screen. And at the bottom of the window on the right side of the screen, you can click that button labeled raise hand. That will raise your digital hand. If you need to check your name and the way you appear, you can hover over your self video until 3 dots appear. Click the dots and a drop-down menu will appear. I often appear as my daughter Maggie, who sometimes does ballet on Zoom, so I like to check and make sure I'm not Maggie. You can just select rename if you need to rename yourself and if you want to share any information about your pronouns. I use she, her pronouns. You can also rename yourself from that participants icon I mentioned above. But we have so much to hear today from our wonderful presenters. We have first Aisling Bondi, who has practiced almost exclusively in the field of immigration and refugee law and has her own practice. I am not going to read these bios. They are very impressive. I hope you will read them, but I want to turn it over to Aisling so we can hear from her.
And Susan, I'm actually going to jump in really quick before Aisling. We have a few poll questions throughout this presentation to engage with you all. So I'm going to launch that first poll, and you can respond to that while Aisling is introducing herself.
I hear the freedom train.
Oh, sorry, let me mute.
Should I go ahead? Should I start? Okay, sorry.
Yes, please do.
I thought that poll question would be a little comic relief midway through the talk, but I guess we launched with it. So okay, so I won't talk much about myself. I'll just launch into my presentation. I am going to be talking about an overview of Canadian immigration law, and then specifically talking about economic immigration. Hannah, are you moving the slides, or do I move them? I guess you're doing it, right? If you want to. Perfect. There we go. So what I'll talk about first is an overview of Canadian immigration law, so types of immigration status and classes of permanent residents, an overview of economic immigration for skilled worker, for entrepreneurs, and then just some kind of concluding remarks and observations to help you. If you can go to the next slide. Thank you. So I wanted to start by saying, because I am covering so much material, I have 15 minutes to do an overview of the entire Canadian immigration system, and economic immigration is going to be pretty high level. It's lacking a lot of nuance and detail, but it's just to really give you a general idea and understanding of it. So I included this photo because I feel like my presentation is to Canadian immigration law. What this photo would be to a visit to Toronto. Okay, it's going to give you a general idea, but not a ton of detail or nuance. All right, so if you want to go on, so I'll start with my overview of Canadian immigration law. Okay, so I think in this regard, the types of immigration status are quite similar to the US. You have temporary residence, the big categories being visitor, study permit, work permit, can lead to permanent residence, and then ultimately citizenship. Some of the categories of work permits might be a little different from the US, but I think overwhelmingly those sort of classes of immigration are going to be, or the types of status are going to be the same. So I wanted to then just break down the various classes of permanent residence applications that exist. I'm not going to get into them in much detail because some of the other presenters will do that. But there are, so these are the main category types that exist for applying for permanent residence in Canada. So we have our refugee determination process, the claim that can be made inland, again, similar to US, and overseas sponsorship. And I think Heather might touch on this, but we tend to use the term refugee in Canada, not asylum. The term asylum doesn't really have, it's not used legally within our legal structure in Canada, but we recognize it. Okay, if you want to move on. There is humanitarian and compassionate. I remember years back going to a seminar delivered by a US immigration for Canadian lawyer for Canadian lawyers. And they were talking about how there is no equivalent concept really in US law to our humanitarian and compassionate class. I've quoted here from the section of the Act, and again, because this presentation is so high level, I've added in, I've removed some sections of it that are nuanced, that are probably more detailed than we need to get into. But a person in Canada can file an application for permanent residence on humanitarian and compassionate grounds, or if they're filing under another class, they can ask to be excused from one of the requirements of the Act or some form of an admissibility for humanitarian and compassionate reasons. And that must take into account the best interests of any child directly affected by the decision. Not anyone in any circumstance can file one of these applications. That used to be the case. That is not the case anymore. There are certain limitations on when you can file either a standalone application for permanent residence or a request for humanitarian and compassionate relief in the context of another application. Anna. We have family class immigration. So that's where someone is being sponsored by a family member. It includes spouse or common law partner, dependent child. More difficult to qualify, but there is a parent-grandparent class, and only to sponsor parent or grandparent, only in very limited circumstances, another member of the family. There is no straightforward program to sponsor a sister or brother or any other family member, other than, again, in some very limited circumstances. And then that brings us to economic immigration, which I'll be delving into in more detail, which includes skilled workers and in some cases also entrepreneurs. So entrepreneurs being people who are looking to launch business in Canada. So now I'm going to get more detail into economic immigration, starting with skilled workers, because it's a little different than the situation for entrepreneurs. The main category that's used in Canada is something called express entry, which some of you may or may not have heard of. In order to, and there's a lot of misunderstanding out there about how express entry works, because it is a point-based system. A lot of people think that anyone can just go into the pool of applicants and get a point score. But in fact, you have to qualify under one of three categories to even access the pool of applicants. So you'd have to qualify, just list them here, Canadian experience class, federal skilled worker, or federal skilled trades. For the most part, so I mean, Canadian experience class is usually going to be people, well, it must be someone who already has Canadian work experience, so you're less likely to be encountering that in the US. Skilled trades can come up. It's very nuanced, the requirements, so I didn't really get into it here. And it can be difficult to qualify because one of the requirements to either have a valid job offer here or a provincial trade certification. And then also you have to meet a point threshold to get through express entry. So federal trades can be possible. It's a bit tricky. A lot of the cases, if you're seeing people who are looking to come to Canada, who might qualify as skilled workers, it's going to be usually under the federal skilled worker program. And I just did a very broad overview of the 4 requirements that are involved to qualify under that class. So you move on, thank you. So let's say someone qualifies under one of those 3 programs. they can't just file an application. They have to go into a pool of applicants online. When they enter the pool, they're given a point score, and this is the list of factors that's considered in giving their point score. I won't go through them, you can have a look at them, but one thing you'll see is that there's a lot of connection to Canada, right? You can get points if you've worked in Canada, if you've studied in Canada, you have a sibling in Canada, or a valid job offer, or trade certification here. So it's increasingly difficult for people who do not already have that qualification in Canada or that connection to qualify. It's possible, but it's challenging. And we've seen that the minimum point score to be invited out of the pool has been increasing over time, making it even more and more difficult for people who can't get those points or having the connection to Canada to qualify. But it is a possibility, especially if you're dealing with someone who has postgraduate studies, fully fluent English, and some skilled work experience in the US. There's a chance. And we have helped people who did, for example, masters in the US, were fully fluent in English, didn't have options to get status there, instead applied to Canada and were able to get through and get permanent residence in Canada. So you go into this pool of applicants, you're given a point score, and periodically the government invites, they'll just one day say, okay, everyone with this point score or higher gets to apply. So if there's not a minimum threshold that's announced in advance, they just every 2 or 3 weeks will say, everyone in the pool today with X score, you get to file an application. And if not, you sit in the pool waiting. If you receive that invitation, then you have, I say 2 to 3 months because it was 2, then it was 3, then it was back to 2, now it's back to 3 with COVID. So it fluctuates over time. You have 2 to 3 months though to file the application for permanent residence. Immigration makes a decision within 6 months. So if you have someone who qualifies, this is an excellent category, but it's just really difficult to qualify and to get that invitation. But if you do, I mean, if you're looking at like around 2 to 3 months to apply, 6 months to a decision, and sometimes it's less than 6 months, you could have someone here relatively quickly, but not everyone's going to qualify. Thanks. Yeah. In Canada, and I don't know if this exists in the US, the provinces can also establish their own categories of immigration. And that's just under the Constitution. Immigration is joint federal and provincial jurisdiction. And so the way it's been worked out is that the provinces have a certain number of allotments of people who they can nominate who they want to qualify for permanent residence. If the province nominates them, they still apply for permanent residence through the federal government. If there's nothing different about their status if they come through a province, but basically the provinces have the ability to select candidates they're interested in. We have 10 provinces, 3 territories. All 10 provinces have their own program, 2 of the 3 territories do. So I'm not going to get into all of them because that would take a very long time. But there's 2 ways the provinces go about it. One is that they can go, when I was talking about that express entry pool of candidates, they can go in there and identify people who they are interested in, or they also have standalone programs. So criteria published on the website. If you meet the requirements, you can apply directly to the province. If they nominate you, then you apply with that nomination to the federal government for permanent resident status. Generally speaking though, because I speak with people all the time, like, I don't care, I'll go to any province, I must qualify under any of them. Most of the provinces are again looking for previous work or study experience there, a job offer in that province, or in some cases, a close family member. So if someone does not have any connection like that to a province in Canada, it's possible, but it's challenging. Again, overwhelmingly, it's going to be people who already have that connection. There's also some other regional immigration programs, and Canada seems to be moving in this direction of kind of giving more authority to regions to be able to identify the people who are of interest to them. So there's an Atlantic immigration pilot, which is for all of the Atlantic provinces. There's also a rural and northern immigration pilot in that participating communities, so they're selected by the federal government, also have the ability to identify candidates of interest to them. Again though, for example, Atlantic immigration pilot, you need a job offer in the Atlantic, right? So it's again back to people who have that connection, who already have the job offer. Rural and northern immigration pilot, each community has their own requirements established, but they get a lot more people contacting them than they have allotments to nominate people. So from my understanding to date, the people who are being selected are mostly people who already live in those communities, maybe as foreign workers, and haven't been able to qualify under express entry. So they're looking to help those people stay before bringing in people abroad. So again, you're seeing like the whole system is really focused on people who are already in Canada and working. So I'm going to talk quickly about economic immigration for entrepreneurs and investors. So what we don't have right now in Canada is a federal program for investors. Investor meaning, and this used to exist, here's a certain amount of money, Canadian government, keep it for 2 years, give me permanent residence, then I get back my money without interest. That no longer exists. It used to exist, it doesn't. There's also no federal entrepreneur program, which also used to exist. I'm going to launch a business, I'm going to employ a certain number of people, give me permanent residence. That program also no longer exists. What we do have are the following. And I should point, Quebec does have a passive investor program, but it's quite sort of limited who can qualify for it. So what does exist? There's a self-employed person program. It is for people who are self-employed, who are looking to be self-employed in Canada in sports or in culture. And they have to have either experience being self-employed in one of those fields, in sports or culture, or what they call world-class experience. So that could be considered an entrepreneur program because it's people coming to be self-employed. Each of the provinces also has an entrepreneur program. So when I was talking about the provincial nominee programs, so they have them for people who are looking to come and establish a business. The process and the criteria for that vary significantly from province to province in terms of the amount of net worth of the individual, the amount of the investment, what industries you can and can't invest in. Some of them, it's a more straightforward process. Some of the provinces, like you have to file an expression of interest, then you get a point score, and then you go into a pool of candidates, and you wait to be invited, and then you apply. Like some of it's a really long, drawn-out process, and you might get through 5 of 6 steps and fail at the 6th. So they exist, but they're kind of cumbersome programs. The federal government, as I said, does not have a direct, straightforward entrepreneur program. What they do have are work permit options for entrepreneurs and investors, which I won't get into in any great detail. But because practicing the US, you know, NAFTA, now renamed CUSMA, there are options there for example, investors. And that's bilateral, so those same work permit options would exist for, if we're talking about US citizens who are looking to invest in Canada, but there's other programs as well that exist for people who are looking to launch a business in Canada. So one option people have is to come on one of those work permits as an entrepreneur, work in Canada, and then use the Canadian work experience to qualify under express entry. And that's really what we're seeing more and more, is because it's so difficult to qualify for express entry if you're not yet in Canada. And it's so difficult to get a job offer if you're not yet in Canada from an employer. It's not just a letter saying like, here's a job offer, done. They have to go through a whole process to validate it. More and more we're seeing is people finding ways to get to Canada, to study, work here, and then apply for permanent residence because they're just not getting the points otherwise. So people coming as international students, when they graduate, they can get a work permit in most cases to remain and work after they graduate. Coming as entrepreneurs, going through other means, working here, studying here, and then they're getting all those extra points for express entry and applying to stay that way. And that's what's making it so difficult for people who have not yet worked or studied in Canada to be able to stay. And my understanding is that's maybe different from the US system in that I don't, like, because I've spoken sometimes with Canadians who've gone there to work. I don't know a lot about US immigration laws, but that it can be, even if you've lived and worked there, that doesn't necessarily assist you in transitioning to permanent residence. The Canadian system very much is about that. If you're already here, studied and worked, they want to make it easier for you to stay.
You know, actually, jumping in with a maybe 2-minute warning, but I do want to say that in many ways the American system actually punishes you for previously having been in the United States either as an asylum seeker or in some cases, you know, if you've had any, you know, certainly any visa overstay, any unauthorized work, already being here is often almost a bar to proceeding in the employment-based immigration system. So thank you so much for that overview of a very different approach.
Well, I should add some nuance that the system, it does give you points for authorized work. So if you have unauthorized work and work as a refugee claimant, although it's authorized on a permit, you don't have temporary resident status, so that work usually won't qualify either. So they have intentionally designed the system to make it difficult for people who come as refugee claimants to transition to the economic categories, and people who are out of status. But one thing I think is a little different, because again, speaking with people in the US, it's not as difficult to, if you're here out of status, to transition to permanent residence through the family classes. They actually make it, I mean, there's no outright bar, and there's a program to be sponsored as a spouse from within Canada, and they exempt you if you have unauthorized work in Canada, unauthorized stay, even an outstanding removal order. They might sometimes try to deport you in the meantime, but technically it's not a bar to being landed. But people who come on work permits, they definitely make it easier to stay. So I know I'm more or less out of time, and I think some of these kind of concluding observations I'd already gone over. One thing I just wanted to just highlight is a second point. So, I mean, if you are dealing with people on a regular basis who are potentially interested in coming to Canada, just what are scenarios where you should say, okay, maybe this is someone I should send to a Canadian immigration lawyer to speak with? Because we clearly don't want to send everyone who has no chance and they're kind of spending money on nothing. If someone has, so this is like in terms of express entry, someone who could have a good shot, if they have master's or PhD, under 30, 3 years of skilled work experience, perfect English or French, that would be really great. Those are people who could have a good shot. Sorry, perfect, I mean fully fluent. They get bonus points if they have a sibling in Canada. And definitely francophones, because there's more points for speaking French than for speaking English. If you speak French alone, that's fine. You do not need to speak French and English. It just has to be one of the two official languages. If you have both, you get like, you get a lot of points. And then I just went over, which I kind of already touched on, strategies that people don't qualify that they're often using is trying to find the job offer here, completing post-secondary studies here, or launching a business. And I know I've gone over by a few minutes, so I will wrap it up. Thank you.
Thank you so much, Aisling, and thank you for kicking us off with that poll question, even if you intended it to be a mood lifter later on. I wish I were at my office because I have this awesome coffee mug of a character from that show, say Moira Rose saying, "The world is falling apart and I'm dying inside." And that's really a good segue to our next presenter, Erin Simpson, who, in addition to having the impressive biography on your screen that I hope you will read, and particularly her role as counsel in the Safe Third Country Agreement that she's going to talk about, I learned today is an inspirational mug collector. And so we will hear from Erin. Thank you.
Thanks for kicking me off with an embarrassing anecdote there, Susan. I appreciate that. It's nice to be here today, and I look forward to speaking to folks again, as Aisling was saying, at a very high level about the who can make a claim at a refugee claim at the Canada-US border. So the basic goals of my presentation today are to answer three key questions. First, who can make a refugee claim at the Canada-US border? And I'm going to do that over a couple of different potential time periods. So now, under the law as it stands, and post-COVID travel restrictions, under a variety of possible outcomes in the Canadian challenge to the Safe Third Country Agreement. Second, I want to answer the question, what is the basic process? And third, which I think sort of runs throughout this, which is when should you consider a Canadian consult? So in particular, what I'm going to cover is the first three segments of this really cover the background law operating at the Canada-US border with respect to refugee claims. And then the fourth segment is going to tie it all up with the attempt to summarize, so basically who can make a claim at the Canada-US border, and then, which I think is related to the question of when do you consider a Canadian consult for your client. quickly, and Aisling alluded to some of these, but I want to make sure folks have a good sense of the terminology that we'll be using in Canada, which of course is different than in the US asylum system. So Aisling already said that whereas in the US, you would likely talk about seeking asylum for anyone who is already in the United States and is seeking sort of relief from deportation and Convention on the Rights of Refugees protections. In Canada, we talk about refugee claims still. The Immigration and Refugee Board, or the IRB, is the independent tribunal with the jurisdiction to adjudicate refugee claims. And this happens in the first instance at what's called the Refugee Protection Division, or the RPD. So you'll hear me talk about a claimant who has been referred to the RPD. That means that their claim is under the jurisdiction of the IRB and the RPD in particular. And there is also a Refugee Appeals Division within the same tribunal, which some but not all claimants have access to. Eligible, ineligible, essentially ineligible claimants cannot have their claim referred to the IRB. So if you are ineligible to make a refugee claim in Canada, then your claim does not get referred to the IRB. However, you may have access to what's called here a PRAW, which is a pre-removal risk assessment. Normally, this is a paper-based application, and in exceptional circumstances, there may be a hearing, and I'm putting that in heavy air quotes because it is essentially an interview with an immigration officer. And this is still an assessment of whether or not an individual would face a risk, that would fall under a refugee analysis or a Convention Against Torture analysis if returned to their country of origin. It is not always available, and I'm going to try to explain some of the places where it would be available as an alternative to a referral to the IRB, and the other instances where it would not be available. There is also a new concept in Canadian law as of spring 2019, which is called the enhanced PRAW, which allows a hearing if the application can't be granted on paper. So those are the basic terminology I want to make sure we have a sense of while we dive into these topics. Again, at a very, very high level, with the same caveat that Aisling gave, which is really, I think our goal here is to give folks a sense of issue spotting for their clients and when some clients may have an option in Canada and it's worth pursuing a legal consult with a Canadian lawyer. So at a very high level, the port of entry refugee claim process, a person makes a refugee claim. There is an assessment of whether or not they are eligible to make that claim. This is not the same as a credible fear interview. While claimants are asked questions about the nature of their claim and about the nature of their fears, those are primarily for documentation purposes. And what the officer has an obligation to assess is whether or not they meet one of the ineligibilities listed in the Immigration and Refugee Protection Act. The major one that is relevant at the Canada-US border will be the Safe Third Country Agreement, or the STCA, and I'm going to explain that in the next few slides. There's also a new ineligibility that's called the Five Eyes or BIA ineligibility, and we'll also cover that. If you have a convention refugee status elsewhere, you've made a past claim in Canada, or you're otherwise inadmissible, and that's going to be covered in a separate presentation. So once the officer has, once the individual has made a claim, then there's an assessment of whether or not they're even eligible to make that claim. In some cases, there may be access to a challenge to that ineligibility. This is in very limited circumstances, and it's very difficult to make at the port of entry because the process is fast, and the act requires that the person be, that if they are not to be admitted and they're ineligible under the Safe Third Country Agreement, that they're to be removed as quickly as possible. And but there are some circumstances in which you might be able to challenge that ineligibility, and we'll cover that as well. And then you're in some cases the person may be admitted and have access to a pre-removal risk assessment. So again, we're going to get into the details of these, but I wanted to ensure that we had a broad picture overview of what the process would look like. The Safe Third Country Agreement. This is an agreement between Canada and the United States that is intended to be a refugee sharing agreement. And the principle of the agreement is you're in a safe country now, so you ought to seek protection there. And so what that means in effect, and sorry, this has been in place since 2004. In effect, what this means is that individuals who seek refugee protection coming from the United States and trying to seek it in Canada are found ineligible to seek refugee protection in Canada. This is a finding that stays with the claimant. So once you are found ineligible, you are ineligible. Those individuals are then returned to the United States with documents that are transferred to Customs and Border Patrol, and that is detailed in the agreement as well. And once they are returned to the United States, they are frequently detained by US authorities. And the fact of having made a claim in Canada and been found ineligible is often a factor in finding that they are removable from the United States. So it is very important to proceed with caution when you have clients who are thinking about approaching the Canada-US border. Individuals who are subject to the Safe Third Country Agreement at the border do not have access to a pre-removal risk assessment in that. They are sent right back to the United States. The application of the agreement. So the agreement applies at all land ports of entry between Canada and the United States, and at the airport if the individual is in transit after removal from the United States. So that's a fairly narrow subclass of people who are affected by the agreement. The agreement does not apply at marine ports, and that includes ferry crossings. It also does not apply at airports. So if an individual is able to board a flight from the US to Canada, and they are not in transit being removed from the United States, then they are not subject to the Safe Third Country Agreement. Inland, meaning if an individual has managed to enter Canada outside of a port of entry and then presents themselves at an immigration, refugee, and citizenship office inside Canada to seek refugee protection, the agreement does not apply to them. And of course, as we've all seen over recent years, since 2017, the agreement does not apply outside of ports of entry. The most well-known of these ports of crossings being at Roxham Road. There are exceptions and exemptions to the agreement as well. So even if the claimant is at a place where the agreement applies and they would otherwise be found ineligible, if they fall under one of the exceptions to the agreement, then it does not apply to them, and they may be permitted to enter Canada and seek refugee protection and have their claim referred to the IRB. This includes US citizens. So US citizens who are making a refugee claim protection against the United States are not subject to the agreement. Habitual US residents who are stateless, that it also does not apply to them. Individuals with close family members in Canada, and I'm going to cover that in the next two slides because this is by far the most common exception and the most important one to look for with your clients. Unaccompanied minors, so this is individuals who are under 18 years old and are not traveling with a parent or a guardian, and the parent or guardian is not in the United States. Individuals who are exempt from the requirement to have a visa to enter Canada, but require a visa to enter the United States. So interestingly, and many of you may not be aware of this, but Canada actually lifted the visa requirement applying to citizens of Mexico in recent years. And so this currently applies to Mexican citizens who would be required to have a visa to enter the United States, but are not required to have a visa to enter Canada, are accepted from the have an exception to the Safe Third Country Agreement. And then there is a final exception for individuals who are charged with a crime and subject to the death penalty. This is a very rarely applicable exception, but you will see when you look at the list of exceptions in the Canadian legislation and on the website that there is a public interest exception, but that has been narrowly defined to just mean people who are subject to the death penalty. I have included here, oh, sorry, Hannah, can you just go back? I've included here a link, which is very useful. This is a Government of Canada website, and it has an excellent summary of the exceptions and exemptions to the Safe Third Country Agreement and of the Safe Third Country Agreement itself. So I know these PowerPoint slides are going to be shared afterwards, and that is a very useful resource. As I said, I want to get into a little bit of detail about the family member exception to the STCA, because it is so common and an important exception to look for. So individuals who are wanting to seek refugee protection and have one of these family members in Canada fall under an exception to the agreement, provided that, and Hannah, if you can switch the slide now, that family member has one of these immigration status, these immigration statuses in Canada. So if their family member is a citizen, a permanent resident, a protected person, which means that they have been granted refugee status or protected person status under the Immigration and Refugee Protection Act, that they have a valid work or study permit in Canada, or that the person, the family member, is a refugee claimant whose claim has been referred to the IRB and is over 18. Now, this is important. So just to flesh this out a little bit more, what this can often mean in practice is if an individual, say for instance, a family, a mom, a dad, and 2 children, and the mom has a sister in Canada, and the sister is a permanent resident in Canada. The mom, therefore, has an exception to the Safe Third Country Agreement because her sister is in Canada. And the children do as well because their aunt is in Canada. But the father does not because his sister-in-law is in Canada, but that doesn't qualify under the list of exceptions. Now, if the mom and the kids come in and they have their claim referred to the IRB, then they might fit in under this last category and then be able to be the family member for the dad. The timing of all of that can be complicated, but that is how that can happen. And I want to put a little asterisk next to that because we're going to talk about this when we talk about the new ground of ineligibility, to talk about how that might, in some cases, become problematic. There is, as Susan mentioned at the beginning, an ongoing court challenge to the Safe Third Country Agreement. The challenge was launched through 3 different cases, one that started in February 2017, another that started in May 2017, and the final that started in July 2017. Those cases were all consolidated in federal court. They collectively alleged that the agreement breached the Charter of Rights and Freedoms because individuals who were sent back to the United States were being frequently detained, that they were being placed at a higher risk of refoulement to face persecution, that this amounted to gender-based discrimination because of the treatment of gender-based asylum claims in the United States, and that it was an unlawful exercise of government powers, which is a distinct ground than the charter violations. This litigation has been going on for since that time, so more than 3 years. In July 2020, we were thrilled to get a ruling from the federal court finding that the agreement was in fact unconstitutional. the principal grounds on which the judge made her decision was that individuals are detained when they are frequently detained when they are returned to the United States under this agreement, and that is linked directly to the Canadian action of having found them ineligible and sending them back to the United States, and that this breached their right to life, liberty, and security of the person, and also placed them at a higher risk of refoulement because of the risks created by being in detention. Unfortunately, the declaration from the federal court finding the agreement unconstitutional was suspended to January 21st, 2021. So what that means is that the declaration, the unconstitutionality finding, doesn't come into effect for the 6 months after the ruling came down, and that means that the agreement is still in place now. And so the situation at the border remains that the Safe Third Country Agreement continues to apply. I've included there a link to the publicly accessible legal information website in Canada, CanLII, with the decision itself, in case it's of interest. I think there's some really useful findings actually for American lawyers about detention conditions in the United States. Unfortunately, the Canadian government has decided to appeal the decision and is going to court, to the Federal Court of Appeal, to argue that there were legal errors and actually that the Safe Third Country Agreement remains valid in law despite the quite dramatic changes since 2017 and the problematic policies and laws that have been passed in recent years. Right now, we're at the point, and actually right in the thick of it right now, that the government has filed a stay motion seeking to what would, in essence, be extend the suspension of the decision through until the Federal Court of Appeal makes its decision. And so that motion is will be considered in the next month. The respondents, which is our side in this, our materials are due on Monday, and then we have the judge will have an oral hearing on it, and the decision will come down after that. And the government has also asked for an expedited appeal, and I put that in quotes because it's actually not going to go that quickly. The hearing on it will likely be at some point in either February or March, and everyone's materials are due by sort of late January. So that is still in process now. Thanks. All right, so moving on, that's the Safe Third Country Agreement, which is, as I said, just really the dominant policy at the Canada-US border. Right now, of course, we have COVID travel restrictions. As you all are probably aware, there are broad travel restrictions at the Canada-US border. These are imposed through an order in council pursuant to the Quarantine Act. I have included here at the bottom a link that takes you to a web page that has it's all of the sort of COVID relevant acts and regulations. The reason I took you to that link rather than taking you to the actual order in council is that the order in council is renewed monthly. It was just renewed again yesterday, and the provisions do change. So it's very important when you have a client who you think may fall under one of the exceptions that I'm about to cover, that you first look at the source law and again seek Canadian consult on this, because the provisions of the order in council have been changing. The basic travel restrictions right now are that there are no refugee claims either at ports of entry or outside of ports of entry. So regardless of whether or not the Safe Third Country Agreement applies, the COVID travel restrictions apply. There are some exceptions to this general bar, but that should be an important take home. We do know that there are still people who are trying to come up through Waxham Road and they're ending up in real trouble. And so an important take home is the general rule is there are no refugee claims right now at the Canada-US border. Exceptions to that are if you are at a land port of entry and you fall under one of the STCA exceptions that I just mentioned. So people who are accepted from the Safe Third Country Agreement can still seek refugee protection at the Canada-US border despite the COVID travel restrictions. Outside of land ports of entry, there is a narrower set of exceptions for US citizens, stateless habitual residents, and unaccompanied unmarried minors. Okay, now the important distinction in terms of what will happen to individuals who do approach the Canada-US border and are not able to make a refugee claim right now under the COVID travel restrictions is that they are given what's called a direct back to the United States. The direct back, the premise of the direct back is that people are going to be able to return to the Canada-US border to make a refugee claim after the travel restrictions are lifted. So it is different than being found ineligible under the Safe Third Country Agreement, because that finding follows you and you can't make a refugee claim in the future. However, if you approach a land port of entry, and in addition to the not falling under an exception to the COVID travel restrictions, you are also ineligible under the Safe Third Country Agreement. My understanding of the current practice is that they will find you ineligible and not simply direct you back. Okay, so both sets of laws are operating at the Canada-US border right now. Thanks, you can go on. And then I'm going to do this very, very quickly because I know I'm running out of time, but I want to flag other ineligibilities to watch. So the major ineligibility that operates at the Canada-US border is the Safe Third Country Agreement. We will also have, there is a new law that was passed in spring 2019. It is sometimes called the Five Eyes ineligibility, and that is because it applies to individuals who previously sought asylum in one of the Five Eyes countries, which are the Five Eyes countries that share intelligence information. And these are Canada, US, Australia, New Zealand, and the UK. And what this really actually was targeting people who had previously made asylum claims in the United States. And it says that they are ineligible to seek refugee protection in Canada. Important in this is that even if an individual approaches the Canada-US border, they fall under a Safe Third Country Agreement exception. So they're not ineligible under the Safe Third Country Agreement, but they are ineligible under the Five Eyes ineligibility. They will be admitted to Canada and given what's called an enhanced PRAW, which is a pre-removal risk assessment with a hearing. Okay, so I want to make that very clear. Those individuals, even though they're ineligible to have their refugee claim determined, they could still be admitted to Canada to have an enhanced PRAW. Okay, I'm sure we'll have questions about this because it's a bit confusing, but it is not an ineligibility that results in a sort of refusal to admit. Okay. Another thing I want to flag, and I mentioned this before as an asterisk, is that those individuals will not be referred to the IRB, so they cannot then be an anchor relative for the purposes of Safe Third Country Agreement exceptions. Okay, it's a bit confusing, but it's very important. So if we return to that example that I gave with a mom and a dad and kids, and the mom has a sister in Canada, and so she can come in and the kids can come in because they have an anchor relative. If that mom has previously made an asylum claim in the United States, then she won't be referred to the IRB, and that way she cannot act as an anchor for her husband. Okay, and so I know from folks in Buffalo that they're seeing a lot of families be basically separated in this manner when one part of a couple has an anchor and the other does not, and this new ineligibility is aggravating that for folks. So that's something really important to watch for. Sometimes at the border, the ineligibility is not immediately apparent, and you may have a case where the husband's allowed in, but if the person later becomes ineligible, then you're dealing with a different situation, and it would depend on timing. again, we can get into this in the question. I'm aware that I'm out of time here. I think I covered these ineligibilities, but these are just things to watch for. Andrew Brower is going to get into detail about inadmissibilities, but I just want to flag those other ineligibilities as well.
Thank you so much, Erin. We really appreciate your leadership on all of these issues. And that is a good segue to Andrew Brower, who is Legal Aid Ontario's Senior Counsel in Refugee Law. Go ahead, Andrew.
That's great, thank you. So thanks so much. I recognize that what I'm going to be talking about now may not be front and center in terms of what you're hoping to get from this webinar about Safe Third. But I would ask you to keep these issues top of mind anyway, as you advise your clients about Canadian options, because Safe Third alone is far from full story. Could flip to the purpose, the next page. Thank you. So I'm here to let you all on a little secret about Canadian immigration and refugee law, and that's that it's often somewhat less welcoming and less rights respecting than many may believe. Our reputation is not always well earned. One area in which that's especially true is with respect to persons who've been suspected of nefarious acts or associations. So I'm going to spend the next 10 or 12 minutes giving you a very broad overview of some of the legal hurdles facing these persons, which is to say potentially inadmissible claimants seeking to claim protection in Canada. So to start, it's important to know that even if a claimant can overcome the Safe Third provision, whether they meet a family classic or a family exception, for example, or they come after the Court of Appeal hopefully confirms the unconstitutionality of Safe Third, they may still face a serious problem with respect to ineligibility to proceed with a refugee claim based on inadmissibility. So under Canadian law, a refugee claimant is ineligible to have their claim referred to the Refugee Determination Tribunal, the RDT, if they're found to be inadmissible on one or more of 4 grounds. Those are security, violating human or international rights, serious criminality, or organized criminality. I'm going to dig into each one of those. So the first one is security inadmissibility, and it encompasses several subcategories, several different grounds. As you see on the list there. The first is espionage against Canada or Canadian interests. Then there's 2 types of subversion. So subversion by force of any government, or subversion even without a force component against a democratic government institution or process. And importantly, subversion is not yet well defined at law, so it tends to be applied a little bit willy-nilly by and then the fourth is terrorism. Now, in addition to direct participation in these kinds of acts, a person can also be inadmissible for membership in an organization that there are reasonable grounds to believe engages, has engaged, or will engage in any of those 4 categories of acts. To be really clear, to be inadmissible on those grounds, there's no requirement that the person who's allegedly inadmissible actually present any threat to Canada or to Canadians or frankly to anyone. It is in many senses guilt by association that may do it. There's also no requirement that there be a temporal connection between the period of the person's involvement in an organization and the period in which the organization committed some of these illegal acts. So for example, a person may be inadmissible on security grounds for, say, having handed out leaflets 40 years ago for a political group that only much later committed a terrorist act, long after the individual severed all ties with the group. That may sound like a bizarre scenario, but I can tell you from practice with many of these cases that we see this type of a basis of inadmissibility far too often. And then there are the last two grounds there for security and admissibility. One is actually being a danger to the security of Canada. And finally, committing acts of violence that would or might endanger the lives and safety of Canada. So that's the first of the four grounds. Next of the four, the second is violating human or international rights. That is typically applied to persons found to have committed genocide, war crimes, or crimes against humanity, or who are senior members of a government that has committed one of those or more of those acts. And the definition, senior members of the government, we could go into that and spend the rest of the day on it. We won't. But the threshold is generally that you need to be in the top half of the government, for which you have some involvement. The third ground that we see more frequently is serious criminality. Under Canadian immigration inadmissibility, we have both simple criminality and serious criminality. Simple criminality does not bar you from access to having your refugee claim considered, but serious criminality does. That's defined as having been convicted of an act outside of Canada that, if it had been committed in Canada, would be subject to a sentence with at least a 10-year max. But it also applies to a person who a Canadian officer determines there are reasonable grounds to believe has committed an act, even absent a conviction for it, in another country that is an offense in Canada carrying at least a 10-year max. So, and then finally, there's organized criminality as a ground for inadmissibility. That is what it sounds like, but it's important to understand that it's extremely broad. We're not just talking in this area about large cartels or major gangs, but also small groups of 3 or 4 people who from time to time associate in order to commit a crime. All of these inadmissibilities are subject to an incredibly low threshold set out in the statute of reasonable grounds to believe that the impugned acts have occurred, are occurring, or may occur. So you can imagine the sweep of these provisions. So what happens when a refugee claimant at the border faces potential inadmissibility allegations? One option is that they may, after being interviewed by Canada Border Services Agency officer, or CBSA, if that officer suspects they may be inadmissible, in some cases the officer may give the claimant a chance to withdraw their request to enter Canada and simply return to the US. If that doesn't happen, the process is that the CBSA officer will write up a report alleging the inadmissibility. It's a very, very brief report. It's typically a page. The report is then referred to another division of the Immigration and Refugee Board. You heard about the RPD and the Appeal Division. There's also an Immigration Division, which is responsible for conducting admissibility hearings and detention reviews. So the inadmissibility report gets referred to that division for a hearing, and the refugee claim is put on hold. It's suspended pending the admissibility proceeding. In most cases where this has happened, the individual is then detained and brought into the detention center. In some cases, that initial detention may be brief. Sometimes it's just to complete an eligibility assessment if it's not completed on the day that the person arrives at the port of entry. But a person may also be detained well beyond that on the ground that there are reasonable grounds to suspect that they are inadmissible to Canada. I don't need to tell you, your lawyers, about just how low a threshold that is for detention. Once a person's been detained, they'll have a statutory review of the legality, the reasons for the detention. by that same immigration division of the IRB after 48 hours of being detained. Then there's another detention review after 7 days, and then every 30 days thereafter. Detention can be continued at each one of those reviews, so long as CBSA can convince the division that it's taking necessary steps to inquire into a reasonable suspicion of inadmissibility. Again, a pretty low threshold. In addition, many facing allegations of inadmissibility are also held on the additional ground that they present a danger to the public or to national security. So I'm happy to, if there are questions about Canada's detention regime, we can deal with that in questions and answers. But let's move on. What happens if the person is determined to be and therefore ineligible? In most cases, an inadmissibility finding is final. There is no appeal by the individual who was found inadmissible, although oddly, the minister, the opposing party, the adverse party, does have a right to appeal. The individual doesn't. So the only immediate remedy, there's another one that we'll talk about, is judicial review in the federal court. Judicial review is typically on a, unless there's an error of law, is highly deferential and is subject to a leave requirement. So you first need to establish that you've got an arguable issue in writing before the court will agree to the hearing. If ultimately the inadmissibility finding is upheld, the only remaining remedy is something called ministerial relief, which we'll talk about in a couple of minutes, but which typically takes many years, decades. In the meantime, the individual is ineligible to have the refugee claim referred to the Refugee Protection Division and will be given instead a pre-removal risk assessment, but it's a special kind of removal risk assessment. It's called a restricted draw, ERA. So what's that? You heard a couple of minutes ago from Aaron about folks who are ineligible because of the Five Eyes provision getting access to a so-called enhanced draw. Well, for folks who are determined to be inadmissible to Canada, they get the opposite of an enhanced draw. What they get is a paper-based assessment by a representative of the minister based on opinions by an immigration officer and CBSA officer about, first of all, whether they are at risk, and secondly, whether they present a danger to the public. And there's a balance that happens. Further, folks have been found inadmissible. In most of these inadmissibilities, there are some nuances, but in most cases, they are also ineligible for protection under the Refugee Convention, protection for persecution, and instead have access to protection only if they can establish that they face on probable grounds a risk of torture, cruel and unusual treatment, or punishment, or death. So essentially, cash protection. Even if an individual who's been determined to be inadmissible and be at risk, and even if the risk that they face is found to outweigh the danger they face in Canada, they still don't get status in Canada out of this. What they get is a stay of removal that bars their removal to their own country. It does not bar removal to another country, and it's temporary and can be revoked at any time if it changes circumstances, including in the country to which the person is supposed to send. So I mentioned ministerial relief. That's the only statutory remedy for one of these inadmissibilities. The onus for ministerial relief is on an applicant to establish that granting relief is not contrary to the national interest. Decisions on ministerial relief are made by the minister, her or himself, Minister of Public Safety. Statutory factors for consideration are national security and public safety, but the reality is that the lack of any actual threat to national security or public safety is not determinative of one of these applications. It further takes many years. The last time I got a written estimate from the government on one of these cases, they were estimating 6 to 8 years to make a determination. But we have cases that have waited for over a decade. They are almost always, not always, but almost. So in the interim, while people are waiting, whether they're waiting for a final determination of admissibility or they're waiting for a decision on ministerial relief, the person is relegated to a kind of legal limbo in Canada, which can be completely devastating. They have insecure status in Canada, so they face the prospect of possible loss of status at any time. They face the stigma of security or criminality label, which for many, particularly those who, back home were involved in a liberation movement of which they were very proud, now face the label of being a member of a terrorist organization, which can be devastating. They face family separation. There's no possibility to bring family members here. They face barriers to establishment in Canadian society, including in terms of education, some kinds of employment, and right to vote. And with all of this, they often face serious and sometimes fatal mental health impacts from the limbo status. We have litigation in play right now challenging this state of legal limbo on constitutional launched months ago. But it's going to be a while before we get it. I think I am coming close. Just to be clear, while we've talked a fair bit about what happens at the port of entry, don't take the fact that an individual has come to the port of entry and not be flagged as inadmissible as an indicator that they are home free, because they're not. Inadmissibility allegations findings can come into play even after a person has had their claim referred to the Refugee Board if CBSA noticed or believe that they were inadmissible. It can be raised immediately after having referred the person to the Refugee Protection Division, in which case CBSA can simply reach in and suspend the claim so that it can't proceed to a final hearing at the RPD. The same facts underlying potential inadmissibility, we talked about, like the terrorism, espionage, and so on, can also, of course, lead to exclusion from refugee protection under Article 1F of the Refugee Convention. Further, even if a person makes it through eligibility, successful at the RPD, is granted refugee protection, they may face inadmissibility allegations after refugee protection is granted, even if it hasn't been raised earlier, or even if it has, and it can bar the person from permanent residence status. It may also result in a special procedure to deport them, notwithstanding having granted refugee protection in a process in Canada that's modeled on Article 3. So the upshot of all of this, meeting a safe third exemption or exception and having an otherwise winnable claim, as Heather will talk about in a few minutes, is not in itself the end of the story. The Canadian inadmissibility regime is circuitous and really Kafkaesque, and I don't use that word lightly. Even if a person is ultimately successful, they may end up in limbo in Canada for many years. It can be devastating, especially if they're separated from family. So in terms of advice, I would say that if there's any chance that a person coming to you asking about Canada might fall within the inadmissibility grounds, really it's critical to encourage them to seek a referral to an experienced Canadian refugee lawyer or giving advice about maybe an option. And I think I'll close there and hopefully there will be some questions. Thank you all very much.
Thank you so much, Andrew. I want to get right to Heather Neufeld because she is both a U.S. and Canadian immigration and refugee lawyer, and I really look forward to hearing her kind of uplift us with, after hearing all this law, who do we really want to see as potentially having like a stronger underlying legal claim in Canada? So take it away, Heather. We have a poll here. Do we have Heather unmuted?
It looks like we might have lost Heather.
Oh dear. Well, I'm going to let you check that out, Hannah. And Ruby, maybe you could choose a question for our other panelists to respond to. And Hannah, just break in when we get Heather back on the line.
Sorry about that. So Andrew, we'll just follow up with you because you just spoke. What are some common types of crimes where someone would have serious criminality? Like what are common examples that you see, that you hear about on a regular basis?
I think I'm unmuted now as well, just so you know. Am I?
Yes, you are, Heather. Okay, that's wonderful. Andrew, you want to give us the 15-second rundown and then we'll kick it off with Heather?
Sure. I mean, it's typically a range of assaults as well as drug crimes with larger quantities. Sexual assaults, obviously, interference, those kinds of.
Do DUIs count? Or
No.
Potentially? No. Shoplifting?
No. Again, unless there's an aggravated component,
Okay.
DUI by itself would not.
Okay. And what about shoplifting or retail fraud or theft?
No, so it needs to come within category crimes that in Canada have a max, at least 10-year max. And sentencing provisions in Canada, fortunately, have not caught up or fallen as low as circumstances on your side of the border.
Okay, great. Thank
Hey,
you.
we are way behind on time, so I really want to hear from Heather.
Okay.
Thank you.
Okay, I'm not sure at what point I got muted. So I'm going to be talking about the treatment of particular social group claims in Canada because I think this is a category of particular interest for U.S. practitioners looking at some of their clients who may not have winnable PSG claims in the U.S. given the current state of the case law, and yet, unbeknownst to them, have extremely winnable PSG claims in Canada. So in my presentation, I'm going to talk very briefly about the Canadian test for PSG. I'm going to mention some key differences between the PSG tests in Canada and the US and some of the other ways in which the convention definition is looked at differently. And I'm going to give you a sense of some of the important PSGs that are well recognized in Canada, as well as examples of some particular profiles of people who are being recognized under those categories. I'm also going to briefly mention a type of non-convention-based protection that's available for people who face risk to life. I forgot to mention that in my outline. And then I probably won't have time to talk about other key differences between the US and Canadian asylum systems, but they are included for you to be able to see. So let me talk very briefly about the Canadian test for a particular social group. And this goes back to a 1993 Supreme Court case of Ward. And one of the things I think is interesting about this case and its setting forth of the Canadian PSG test is that the court approved of the test from Acosta that had already been developed. So when you think about the Canadian PSG test, one of the things to keep in mind is think back to Acosta. So the court set forth 3 categories of individuals who qualify as particular social groups. And the first one, like Acosta, is individuals in groups that are defined by an innate or unchangeable characteristic. So the court focuses here on examples like gender, family relationship, sexual orientation as being really prototypical particular social groups. The second group is groups whose members voluntarily associate for reasons so fundamental to their human dignity that they should not be forced to forsake the association. So here we're thinking about individuals like human rights activists or unionists, people who are involved in something that's fundamental to their human dignity. And then the last group is individuals who are members of groups associated by a former voluntary status unalterable due to its historic permanence. That's a group that we really don't end up raising specifically in our arguments. I'm going to mention just a couple of key differences between the Canadian and US PSG tests and the way the convention is interpreted. I think it's important to keep in mind that in Canada, there is no requirement to prove the persecutor's motivation. So for example, you don't have to show that a domestic abuser is abusing a woman because of her status in society, or why a gang member is persecuting someone, only that it's happening. There's also no requirement to prove particularity and social distinction. And this is really key because you can think of Canadian PSG case law as really being sort of back to fundamentals, back to Acosta, without the addition of particularity and social distinction. So you don't have to argue about how the society in the person's country is viewing this group, for example. As well, in non-state actor cases, you don't have to prove that the government condones actions of a private actor or demonstrated helplessness to protect. So there's none of these additional hurdles that are coming out of matter of AB. State protection is really only about inability or unwillingness to protect. I'm going to mention family-based particular social groups. Now, here in Canada, there is no case law like matter of LEA, and family meets the innate or immutable PSG test. So the federal court has definitely confirmed that family can constitute a particular social group. So this is something that really is not in question in any way. Next, I want to mention gender-based particular social groups. And it's important to keep in mind that there's some concepts that are referenced in the Immigration and Refugee Board's gender guidelines, because we do have gender guidelines that decision makers are supposed to follow. And one of the things that the gender guidelines emphasizes is that the size of the group doesn't matter. So you can't say that a social group is too large. As well, a woman doesn't have to prove that the risk is personal to her. She can prove the future risk based on evidence relating to similarly situated women. So for example, a woman doesn't have to necessarily prove that she will be raped, only that women in her country are being raped and that she faces that risk. Now, of course, there are always decision makers who prefer a more narrow PSG formulation. You're always going to get some decision makers who say, oh, a PSG of women in a given country is too broad. So sometimes we do definitely narrow the social group to things like, say, young women or single women as opposed to women in general. Couple of points on domestic violence cases. Again, there's no matter of AB, and really we don't argue about whether survivors of domestic violence constitute a particular social group. In domestic violence cases, our focus is on proving lack of state protection and lack of internal relocation, as well as credibility. But the fact that women fleeing domestic violence constitute a PSG is something that is simply taken as a given in Canada. So there's no requirement that the woman have been married to her abuser. And there's also no requirement that she prove inability to leave. We don't have these extra requirements, nor need she prove that her abuser abused her because of her status as a woman as opposed to his alcoholism or something like that. The next particular social group I want to mention is age-based particular social groups, and particularly children. So you could theoretically have a PSG as broad as children in a given country if you could demonstrate that the risk to children was really widespread. You could also have subgroups of children, and a lot of times I've argued subgroups like, for example, teen boys in a country where that teenager status puts them at risk of forced recruitment, or puts teen girls at risk of sexual violence at the hands of gang members. As well, we often argue a PSG of children of a particular parent, particularly where the children are going to be at risk because of the parent's political opinion, for example. So I want to give you a few examples of some of the PSG formulations that are successfully argued in Canada. We've talked about the groups themselves, but here are some more specific formulations. I think it's really important to mention forced recruitment cases. This is one of the areas where I see cases failing in the US, given case law like matter of MEVG and other cases. And in Canada, these cases definitely, with the right evidence, can be winnable. So you can have a PSG, for example, based on age, gender, and past refusal to be forcibly recruited. So I've had success with things like young male Salvadorans of low socioeconomic status who have a strongly held belief that being in a gang is wrong. And even if you don't include that strongly held belief component, simply their age and their social status and their gender can be enough. There are also a lot of formulations that succeed relating to social groups relating to future gender-based harm. So I have argued a lot of times things like young women who've been raped by gang members and are under threat because they've spoken to the police, or women at risk of future domestic violence, single unprotected women who are at risk of sexual violence at the hands of gang members. And I think this is really interesting because a lot of these PSGs would automatically be thrown out in the US as being too circular, as including the harm feared. And that's something I'm always concerned about, but that doesn't seem to be raised very often as an issue by the decision maker. In terms of family-based PSG formulations, one important one that comes up a lot is women who may be harmed to punish another family member. So think of someone whose partner is being forcibly recruited by a gang and the gang can't find him, so they threaten or harm the woman. Another one, as mentioned before, is family members of someone who's politically active. And another one that's interesting that comes up quite often for male spouses is the family-based PSG relating to being the spouse of a woman who is under threat from a gang, and so that threat would generalize to him as her spouse, or a man who's going to be at risk because of his wife's former domestic partner who would come after her but also come after him. I want to briefly mention another category of protection that we have in Canada that does not have a parallel in the US, and this is called person in need of protection. So you can think of this as essentially an extra safeguard for people who face a risk, a serious risk, but don't fall under a convention ground. And this is a form of protection that goes beyond what you would see in cat protection in the US. And it goes beyond cat protection in two important ways. So unlike withholding under cat, for example, someone who's granted person in need of protection status gets all the same rights as convention refugees: permanent residence, family reunification, right to travel, all of it. And going beyond cat protection, this form of relief is not just applicable to someone at risk of torture or at risk of cruel and unusual treatment, but it's also available to someone who can show risk to life, really for any reason, as long as that risk to life is not faced generally by others from their country. So the not faced generally component can be a huge stumbling block if a decision maker thinks that the risk to life is faced generally in the country. So you really have to try to show how this risk to life is individualized. So, of course, you still have to prove state protection or lack of state protection and lack of internal relocation, but you have this extra ability to argue risk to life. And so typically we would see this for asylum applicants from places like Central America, Mexico, the Caribbean, where gang violence is rampant, or drug trafficking and drug violence. And you can argue, for example, someone who's being extorted by a gang and unable to pay and is being threatened, that may start out as a generalized risk that lots and lots of people are experiencing. But then when that individual goes to the police and complains and is threatened for having complained to the police, that's not something that the majority of people do. So the risk has become personalized, and that individual could succeed on risk to life. Given the lack of time, I think I won't talk about key differences between the Canadian and US systems. I would just highlight in just a few seconds that it's important to note that there is no one-year bar in Canada, and that there are some extra safeguards for children that don't exist in the US, like having a designated representative for all children going before the refugee board. Children have to have someone designated to protect their interests in the refugee process, either a parent if they're with one, or another individual if they are an unaccompanied child. So
Heather, go ahead and finish your content. This is the good stuff, and we got you started a little late.
Okay. I think it's also important, given the changes with employment authorization in the US right now, to note that all asylum applicants in Canada do have the right to a work permit. That's something that they're able to apply for immediately upon entry. And it may take a few months to get that work permit right now, especially with COVID-related delays, but they can access social assistance during that time while they're waiting. I also would point out that it's important to understand that our process is a bit less adversarial than what you're going to see if you're before an IJ, for example. There are no trial attorneys typically present in a refugee hearing. Sometimes the government does intervene on certain issues if there's a really serious credibility issue or an exclusion from refugee protection issue. But in general, it's only counsel and the decision maker who are questioning. Now, you can have, of course, a very aggressive decision maker where it's just as bad as having an IJ and a trial attorney combined. But in the majority of cases, if you have a decent decision maker, it's going to be a lot less adversarial. I would also point out that we do have guidelines that refugee board decision makers are supposed to follow on things like gender, on children, on sexual orientation, and especially on vulnerable persons, which are individuals who, for example, have experienced trauma and their ability to present their case is impacted by that. And what's interesting to note is that vulnerable persons can get special accommodations before the board, like not having to answer certain questions, or having a support person present, or having their counsel ask all the questions first rather than the decision maker questioning first, as is typically the case. I mentioned designated representatives for children. That's very important because in the Canadian system, there has to be an additional person to protect a child's interests, given that a child does not have the capacity to instruct counsel and make all the decisions on their case. And Andrew mentioned detention reviews for people who are detained. The detention reviews take place on a much more rigorous schedule than in the US, and the majority of asylum seekers are not detained. So in conclusion, I think there are a lot of asylum cases that are very difficult to win right now in the US, particularly on particular social group or risk to life for non-convention reasons, that are winnable in Canada. And over recent years, I have asked myself so many times why I'm not seeing more young people from Central America and more women fleeing domestic violence taking advantage of these PSG interpretations.
Well, Heather, I want to thank you. I want to thank all our panelists. I want to thank everyone for your patience with technology. We were never going to be able to answer people's personal questions about their personal cases in this forum, and so I hope you will follow up and hire a Canadian immigration practitioner if you're seeking personalized individual advice, and perhaps one of our panelists today. If any of our panelists can stay on the line, I know it's 11:35. Ruby, would you be able to lift up what you maybe think is the top question, and we could get that answered for the recording before we conclude?
Yeah, so I think a lot of questions that have to do with if a person's already started the asylum process in the United States, kind of at what point is that going to affect their ability to make a refugee claim in Canada, right? If they've applied for asylum, but they haven't had a hearing yet, if they've applied for asylum and they haven't been fingerprinted yet, and kind of like where in that spectrum and how does that affect an ability to make a refugee claim, if we're going to boil it down to one question. There are obviously a lot more. Maybe this just means we need more webinars together to.
So I can take a first crack at that, and others will definitely want to add. The short answer to that question is that is a very good question, and it is still being worked out. The language in the new ineligibility, which again was just introduced in spring 2019, is that a person is ineligible to make a refugee claim in Canada if they have made a claim elsewhere. And so, of course, that gives rise to a lot of questions of, have you made a claim if you've had a CFI interview? Have you made a claim if you've been fingerprinted? Have you made a claim if you've filled out the I-589? There's a lot of questions. Andrew has litigation right now, which is in part aimed at trying to narrow the scope of what it means to have made a claim. And the organization, the Canadian Association of Refugee Lawyers, of which I am the chair of the litigation committee, has an ongoing working group looking at these cases. So I would really urge folks to, if you have clients who have been found ineligible in Canada, to have them reach out to us and get in touch about that. But the short answer to it is it's a bit of a moving target as to what it actually means. And we're just starting to see these cases now where it's fully becoming clear. Andrew or Heather are also on that work, so they may have something to add.
I think I would just also add to just remind everyone that even though individuals who have commenced a claim in the US are ineligible to have a refugee claim heard in Canada, as Aaron said, Aaron also talked about the fact that those individuals would get a pre-removal risk assessment with an interview with an officer. They're calling it a hearing, but as Aaron said, it's really more of an interview. So it doesn't mean that they cannot access anything in Canada. It means that they can't access the full level of rights and procedural fairness that you would have in a full refugee hearing. So some people may still choose to come to Canada and undergo that pre-removal risk assessment process. I think one other element to that is, to what extent will the officer making that decision try to say that this person has less subjective fear because they didn't follow through with their US claim, they left it partway through and came to Canada, and they're not really that fearful because they didn't follow through with their claim. So that's just another element to keep in mind.
And maybe just one question for practitioners generally, or who have clients here but want to make claims in Canada. Are applicants for refugee claims, are they provided counsel? Do they have access to counsel? We saw during Heather's presentation that children and incompetent adults have designated representatives. What's the availability of counsel for people who are not children or incompetent, or does that exist also for detained persons?
It really varies. Thanks for that. It varies across the country. So we do have legal aid plans in many provinces that provide different levels of support. Ontario, which sees the majority of claimants, we have a legal aid plan. I happen to work for them. So we do provide access to counsel for those who meet our very low financial criteria. So you really need to be broke in order to get a legal aid lawyer. Beyond that, you'll need to hire someone privately. Other provinces, it varies.
And just to flag, in addition to what Andrew said, the individuals have to be in the province where they are, accessing those legal services. And so there's often a little bridging that needs to be done. If somebody needs advice while they're outside of the country, they may need to retain a lawyer, if they need somebody to advise on whether or not they need an STCA exception. I didn't get to my last couple of slides, so I do really want to flag that STCA exceptions have to be very well and meticulously documented. And given what we covered about the high stakes for somebody who is found ineligible, you're going to want to make sure that you refer clients to an organization in the United States that helps people prepare those, or to a lawyer in Canada. And in my last couple of slides, and I know these will be circulated, I included a couple of links to organizations in the United States in both Michigan and in New York State that do assist people who are making claims at the Canada-US border with STCA exceptions.
Great.
Yeah, and I would just add that I think all of us are willing to take questions and respond to follow-up after this webinar, because it's a lot of times it's a question of trying to figure out, does an attorney have just a really quick question, or do they actually want to get their client set up for a full Canadian consult, or what exactly people need.
Okay. And if somebody is ineligible for a refugee claim and they need to make a pre-removal risk assessment, does that actually happen at a port of entry? Is that like paperwork that's filed in advance, or is that actually done in Canada itself?
They're usually admitted into Canada and they file it once they're here.
Great.
Great. Well, thank you, everyone. Thank you for running over with us. I look forward to, I hope, a little follow-up with our presenters who are all inspiring, who are all experts. Thank you to all of you who are doing this work on both sides of the border, and have a wonderful day.
Thanks, all of you.
Keep an eye out for a survey on how this went in the next couple of days as well.
Great.
Thank you.
Thank you, everyone.
Bye.